Staying with India, a former Chief Justice of India is headed to the upper house of the Indian Parliament. The President of India has nominated Justice Ranjan Gogoi to the Rajya Sabha. Is this move unprecedented? Is it a blow to judicial independence? And what exactly does the law say about such a nomination? These are the questions that are at the center of most debates in the Indian media. The answers, I'm afraid, are getting lost in the clamour. Tonight, we'll begin with some facts. This isn't a first. It has happened before. India has a long history of former judges becoming parliamentarians, governors, even vice presidents. Take the example of Justice Ranganath Mishra, the 21st Chief Justice of India. He was appointed to the Rajya Sabha by the Congress party. He was an MP from 1998 to 2004, but this was 7 years after he stepped down as the CJI. Another former Chief Justice of India, Justice M. Hidayatullah, was appointed the Vice President in the year 1979, 9 years after his retirement. Many such legal luminaries have gone on to contest elections. Some others have moved from the Parliament to the judiciary. These were the precedents. Let's now talk about the legality of it. Justice Gogoi's nomination is legal. Article 220 of the Indian Constitution only restricts a retired judge from practicing law. There are no restrictions, no mention whatsoever on seeking employment or joining a political party. In Justice Gogoi's case, it's none of the two scenarios. He has been nominated by the President of India himself. But the fact that this has happened less than 6 months after his retirement is raising some questions. Questions about his judicial record. Aspersions are being cast on his objectivity as the Chief Justice of India. The charge is that his nomination is a post-retirement award for delivering favourable judgments. Judgments which were favourable towards the end of his tenure. Justice Ranjan Gogoi did pass some controversial yet landmark judgments. November 2019, he brought an end to the Ayodhya land dispute, a dispute older than the history of the Indian judiciary. Some called it controversial, others said it was long pending. The very same month, he gave a clean chit to the central government on the Rafale fighter jet deal with French firm Dassault Aviation. In both these cases, he was accused of siding with the government. We must note two things here. First, there is nothing to prove these charges or these claims. And second, to call Justice Gogoi's political appointment a quid pro quo is to undermine the authority of the other judges, because we must not forget both these judgments were not delivered by Justice Ranjan Gogoi alone. The Ayodhya verdict was passed by a 5-judge bench. So was the verdict on the Rafale petition. It was a combined verdict by 3 judges. In accusing Justice Gogoi, one will have to hold an array of senior judges culpable. And if the Chief Justice was indeed being asked to toe the line by those in power, why did his colleagues not object? Or do a tell-all press conference like they did against former Chief Justice of India, Deepak Mishra? I'm sure you remember these images on your screens. This was in January 2018. 4 senior-most judges of the top court of India, including the man at the center of the storm, Justice Ranjan Gogoi, protested against the Chief Justice, Deepak Mishra. They lashed out at his style of administration and allocation of cases. This was unprecedented. Listen to what Justice Ranjan Gogoi had to say then.
It's a discharge of a debt to the nation that has brought us here. And we think that we have discharged a debt to the nation by telling you what is what.
The critics of the government then hailed him as the bold voice of democracy for saying this. Today, the very same critics say that he has undermined democracy. On the plus side, a fierce debate continues, and this is the best indicator of a democracy in action.